Money Show.
Personal Finance with Warren Ingram.
Warren Ingram, of course, is a certified financial planner at Galileo Capital. Warren, good evening. So next week is National Wills Week, and I don't know why it is, but I'm always kind of aware of when National Wills Week is. The Law Society of South Africa does it, and you can actually get one free. And I think sometimes we forget, firstly, how simple, and secondly, how utterly vital a will can be.
You're right, Stephen. It's one of those things where when I do a talk to an audience and I ask people by a show of hands to put up their hands if they've got a will, it's usually about half the audience. And that audience might well include lots of people who are parents. And for me, that's always astonishing, that parents, I mean, obviously there'll be an element of illiteracy or ignorance about the need for a will, but for people who know about wills and our parents, it's, this is the public service announcement. Guess what? You really, really, really need a will.
I think there might be two things that come with this conversation. The one is, I think a lot of people think, well, I have nothing really to fight over, so it doesn't matter. And the second is, I don't want to talk about dying. And actually, both of those things aren't really true. You have to talk about dying, and actually, most people do have something that people will fight over if you don't sort it out beforehand.
Yeah. So let's talk about the dying thing. It's true. It's a psychological phenomenon. We don't want to think about it, and we don't we don't think about our mortality all the time. I hope we don't. We're too busy with the business of living. But it is the one thing we all have in common. One day we're all not going to be here, and so we've had so many unfortunate examples for all of us that, if you just keep thinking about the pandemic and all the accidents that happen all around us, it's going to happen. And there is a decent chance that it happens in a way that you have no time to plan and no time to prepare. So, let's kind of just for a little while think that it's one thing we can have, and put in place, and then hopefully it's not required for many decades to come. But maybe to your point around people who say, but hang on, I don't have stuff, it doesn't matter. The thing is, when you've got anything, any possession, and you're over the age of 16 or 18, and you die without a will. What's happening is that the mess gets left behind. So someone has to kind of close your accounts. Nowadays we have social media accounts, and you might have bank accounts, and all of that stuff requires paperwork, and it requires someone to have the authority to approach banks or the big institutions to say, unfortunately, this person has died. And if you've not given anyone that power and that authority to do that, all that happens is you just leave behind a mess. And can you imagine trying to explain, for example, to SABC about your TV license that actually I'm sorry, that person's not alive anymore. Those are tough things to deal with. So you do need a will, even if you don't have tens or hundreds or millions in assets. You just need to be able to do it for good order. And then, if you have children, you absolutely need a will, because who's the designated authorized person that's allowed to take responsibility for your children? You can't just leave that up to the ether, because you might just be leaving everybody, including your kids, in a heck of a mess.
Okay, so the case to have a will is obviously there. The primary function, I suppose, about a will is that it distributes your possessions according to what you want after you've left us.
Yeah. So we need to have in writing a document, and in this day and age, it seems strange and archaic, but it's the reality. It needs to be a physical document, and it needs to be in writing and signed, and quite a few little legal requirements. But it's there to tell the world what should happen to your possessions, to your stuff, in the event of your death. And then, if you have children, who looks after your children. There are a couple of other important things as well, but the primary thing is, this is what happens On my death, this is what needs to happen with my stuff. Secondly, this is what happens with my children, and then who is the person? And the lawyers love jargon, so this is a piece of jargon. Who's the executor of the estate? And that's the person who gets legal responsibility to do the things on behalf of you because you're dead. So they in effect become the person that will wind up your estate and sign up all the documents that are required and give all the instructions as if you were still alive. So it's very important in a document like this that those kinds of things are covered and that you take responsibility for kind of just getting this done.
011-883-0702, 021-446-0567. Your questions for Warren Ingram about wills, voice notes as well on 072-702-1702. Warren, I think there's another perception about being an executor that actually you need to know a lawyer, or if you don't have one in the family or someone you trust who's a lawyer, actually you really can't find an executor. How technical is it? Do you really need to have a mate who's a lawyer?
There are people with no background in law that have successfully wound up an estate, and lots of people. I often hear someone saying to me, "I wound up my mother's estate," and I think that it's not impossible. I think you can go through the process. What I would say is, I would certainly not want to be nominated as an executor on anybody's estate. But number one, there's a huge amount of paperwork. Number two, you're dealing with government departments, especially the Master's Office, that in some of the provinces in South Africa is really not up to scratch. And then you're dealing with the banks and all the other institutions. So you're not giving anybody a kind of a gift or an honor by appointing them as an executor, and certainly. I think getting someone who's got experience in winding up estates to do that would in my view be better, but certainly you don't need to be a professional. And I think often I'd say to people, if you don't want to appoint some nameless lawyer or some law firm as the executor, then you can appoint somebody that maybe is just fairly decent with paperwork and fairly up to date with just their own admin. And then just remind them that they're allowed to appoint an agent on your behalf. In other words, the person can be the executor, but they can subcontract a lot of the legwork around winding up an estate if that's what's required. So that would be the kind of best second prize, I think, if you don't want to appoint a legal professional. But gee, I'd think very carefully about it. It's a tricky thing to wind up an estate.
Sure. T. Sapanya's messaged us on 072-702-1702 saying, "Evening, Stephen. Pardon my ignorance. T, we're learning together. Can a bank you have an account with hold your will for safekeeping even though they didn't draft it?" This is from Table. I don't know if a bank would do that. I mean, I think that's another thing is, where do you actually put a will once you've drafted it?
So I mean, the answer is that they could, but hold your will on your behalf. But I think you're right, Stephen, that they won't do it unless they are the executor as well. So it's not, they won't have a commercial interest in holding a will where they're not the executor. So my suggestion always with this is make sure that when you draft a will, you get two proper copies of the will done at once. So you can keep one in a place in your house where you make sure that you tell people that you trust who are not in your in your household, and I'll explain why now. But so that's one. You tell people, in XYZ drawer in this bedroom is kind of where my will is with all the other pieces of paper that you need to know. And then secondly, if you don't have a law firm that's done the will for you and they keep a copy, keep it at someone else's house that's not in your immediate household. And the reason for that's very simple is, if something happens to your house, let's say you and your family die in a fire, everything's burnt in that house, including some of the people who might have known about where the will is. So making sure that your will is in a different place. So one copy is in a different place and one is in your house is fine. Otherwise, if you do appoint a law firm, they can keep a copy on your behalf.
James from Simonstown says, it must be remembered wills are ephemeral. 5 minutes after a will has been witnessed and signed, their testator, the person I presume who's made the will, can simply renounce the document and sign a totally new will with new witnesses. An attorney may not know they're holding a sort of redundant will. I mean, this is the stuff of American and now Mexican soap operas and telenovelas. But James is right. Legally, I mean, I could write a will now and tear it all up, or not even tear it all up, and then just go home and write another one.
It's a good point, and I'm not sure if that's a critique or not, but to me that's a benefit, because life does change, and certainly people that you appointed as beneficiaries, so people who you want to leave some money to, if their lives change or they're not around anymore and you want to update your will, one of the things that you write in a will is this is the kind of current valid will, and all previous wills are now null and void, and so he's 100% right. But the thing I like about this flexibility is that it's not a contract where, if you've got a will stored with a company in Joburg and you move to Durban, you don't have to notify that company. You can just simply draft a new will and make sure that that this is the new and current one. So I think it is quite flexible. But the point is right. There could be 5 or 6 copies of your wills if you haven't torn them up and had them shredded and told the people that that previous law firms or whatever that they could be around. But the most recent one, the one that's most current in terms of date, will be the one that will then be your valid will.
Okay. Before we move on, and there are quite a few questions coming in, but I do need to do this. What happens if you die without a will? Technically, I mean, where does it go? It goes to government, the problem.
So no. Fortunately, we don't donate all our stuff to government. If we die.
Sorry, I meant the problem, but yes, yeah.
So there is a law it's called the Intestate Succession Act, and it governs what will happen. But just very kind of summarily, it will be up to a bunch of government officials and then executors appointed by them to determine how your possessions are going to be transferred to your beneficiaries. And remember here that you might have got divorced and have a new life partner, and if your will is old or you don't have a will, the government officials might not know about your life partner, and they might decide to leave some of the assets to your ex-spouse, because your ex-spouse is going to be responsible for the children, and you might have had a plan to leave all the assets to your children, with another responsible adult taking account of the money and looking after your children financially. So you can end up in a situation where your possessions get allocated to people that you wouldn't have wanted to benefit, and potentially that your children end up being looked after by someone that you certainly wouldn't have wanted to take responsibility. So what you're leaving behind is just one enormous mess.
And I mean, it's a reminder really of how you actually need to sort of take care of things yourself. All right, we've got more questions about wills. We're going to hear them in just a moment. First, we also have a question. In fact, we've got a voice note or two. Let's hear the voice notes. They've come through on 072 702 1702 about wills for Warren Ingram this evening.
Good evening, gentlemen. Number one, where do I get the will? Do we have something drafted on the internet we download and we write it? Or is there a specific place where we have to go to get the will? The second question, how does a parent choose an executor? What steps must be followed to choose the executor? Thank you.
All right, thank you for that. We'll have an answer for you from Warren in just a moment. 10 minutes to 8, Personal Finance on The Money Show.
The Money Show. Personal Finance with Warren Ingram.
Warren Ingram, of course, is a certified financial planner at Galileo Capital, and we had a couple of questions coming through on WhatsApp and a voice note. And the one question, we've spoken about an executor a little bit, but where can I get the will? Is there something on the internet that I could use, for example, Warren? And I think I've seen them lying around. You can actually get a sort of vaguely pre-drafted will.
Yeah, there used to be templates, that you could go to the stationery shops and go and buy one and then draft it fill it in. But what I would suggest is, and this is a great initiative by the Law Society, in every province in South Africa next week, There are law firms that have signed up and registered to provide a simple free will to people who come in next week. So if you go onto the Law Society's website and or just search LSSA National Wills Week, you'll see there's I'm looking at their website now, and there's a list of all the provinces, and then select the province and go and find a law firm in your area that will do the will for you. I think it's a great initiative because sometimes these wills can cost you sort of 500 to tens of thousands of rands. So if you have simple requirements, you can't go in there if you're a multimillionaire expecting a really complex will, but you can go there, and I think that for me would be a great initiative for people to take advantage of next week. So I just want to talk about the executor and maybe the guardian, Stephen, because that's easy to get confused. So the executor is the person that takes responsibility for winding up your estate, all the legal processes, etc. But in your will, you should nominate the guardians of your children, and that doesn't have to be the same person as the executor. So the guardians, you might say, I'm happy for my sibling, one of my siblings, to take responsibility, or for a very good friend or somebody. But what you should do in your will is name them, and identify them, and then don't then let them find out, just on the reading of the will, that they are now responsible. So for me, that would be the ideal. But they don't have to be the same person. The guardians of your children and the executive of your estate can certainly be two separate people entirely.
Some interesting messages coming through. Grunge says, what happens if I have a will I write myself without help from a lawyer and assign it to someone that I trust? Is that sufficient? Am I right? So long as it's witnessed, I think that might be right.
Yeah, I think if you're going to do that, and then take some time just to do a bit of reading. Again, on there are quite a few good government websites and the Law Society website which will explain what's required for a valid will, because you need two witnesses, and they have to be there, and in you have to sign that will in your in their presence. Those witnesses can't be people who are beneficiaries, so that you can't get your kids to witness it, or your favorite cousin who's going to get half your estate. So there are some important requirements. As I said, has to be in writing. You have to sign every single page. And it must be done. Your signature must be with. They talk about wet ink. In other words, it can't be an electronic signature. So do your homework properly if you're going to decide to do it yourself, and don't just trust the kind of the first source that you see, and certainly don't look at some sort of influencer's website and think that you've got all the answers there.
We got so many questions actually on this tonight. So Lynn is asking, any advice regarding the situation of the only surviving child's overseas? I live on my own. Can this person be the executor of my affairs without having the power of attorney? They're unable to travel for some time. I imagine so long as you can get the signatures sorted out, and in this day and age, that shouldn't be too difficult. It should still be fine.
Yep, I think it's you can appoint that person to be the executor, and then what they could do is appoint an agent in South Africa to take care of most of the legwork that's required, and so that's certainly possible. But I mean, in a situation like that, just do the work with them as well, to say, well, here's a list of good sort of companies that you can appoint as an agent to help you as an executor.
Okay, and then where was the question now? So interesting sort of feedback, if you like. Finley says things run smoothly with an attorney. Banks are full of red tape and impersonal. And Co says, based on my experience, people should name a family member or one of the beneficiaries as executor and specify in the will they should get a lawyer to work with that executor. Horrible experience with the bank as an executor. Obviously, everyone will have their own experience, but clearly bank's not having an easy night tonight.
Yeah, I think just to understand, I mean, you've got a bureaucracy on the one end, which is government and the master's office, and then you've got potentially the bureaucracy of a bank on the other end, and so two bureaucracies trying to kind of work together to wind up something which is usually quite complex, being your estate. So that is why I would say to people, I mean, I don't, I'm certainly not an executive, but I would always want to have someone that's experienced to get this done as fast as possible, and estates nowadays seem from my kind of anecdotal evidence to take two years at least, and sometimes, could take 5 or 10 years if you've got a real mess. So it is quite a process, and certainly you want someone that's efficient and experienced if you have a bit of a complex estate.
And then there's another question around having a trust. Would that actually complicate matters if you now have a will? Does a trust sort of complicate the whole issue?
Not really. In fact, the thing about a trust is that the law sees a trust as a separate person from you. So if you've got most or a chunk of your assets sitting in a trust, the fact that you've died doesn't end the trust at all. The trust carries on living, and so that could help simplify things. What you just need to do is make sure that your will does tie up with the trust. In other words, that it knows that the trust is there, and that you acknowledge that some of the assets need to go into the trust, or the other way around if you're dying without much money in your own name, and there's some costs that need to be covered. But certainly that doesn't necessarily make life more complex. It could in fact make life a bit easier and save you some taxes and estate duties, etc.
Warren Ingram, thanks so much. Co-founder of Galileo Capital. So many questions tonight on wills. National Wills Week next week. You can, through the Law Society, get your will done for free.